This is regarding a class action lawsuit against Google. If you're somebody who has a phone that is manufactured with default of Google in it, you are eligible for being a part of this class action lawsuit. You're probably not going to be getting a notification by mail because they are sending out the notifications via Gmail. Because everybody has a phone, has a Gmail account. Because they force that on people. Which that monopoly, by the way, attorney generals are trying to break up. Anywho's, this was from September 30th, 2024. I recently checked my Gmail and I saw that in my spam folder, which I was just going through and just removing, just freeing up my storage. And so I went to my trash and I went to my spam, and how about Google decided to spam notifications against themselves of a class action lawsuit. So this, of course, is a problem and fraudulent because they know that it is not a scam or spam, that it's true. So I will be contacting the attorneys and the court regarding what Google is doing, trying to hide notifications of the class action lawsuit. Part of the reason it's important for you to take action, because if you do not respond, you will automatically be included in that lawsuit. And there's various reasons why you may not want to be. You can opt out. Because you can file your own lawsuit, right? I personally don't want to be a part of any class action that's by attorneys, private firms. If it's an attorney general type of lawsuit, it's different. But so this is how it came about. Video game maker Epic Games sued Google and Samsung, by the way, on Monday, using the tech companies of coordinating to block third-party competition and application distribution on Samsung devices. This is why I say the settings that you choose in your phone, yeah, I don't really know that always helps. Okay. Anyways, that's kind of always been my opinion on that. I do recommend setting them. I always block my ads, like first thing I do when I get a new phone. At issue in Samsung's auto blocker feature, which only allows for apps from authorized sources such as Samsung Galaxy Store or Google Play Store to be installed. The feature is turned on by default but can be changed in phone settings. The tool prevents the installation of applications from authorized sources and blocks malicious activity, according to Samsung. In a lawsuit filed in San Francisco federal court, Epic's second against Google, the company said AutoBlocker is virtually guaranteed to entrench Google's dominance over Android apps distribution. Epic developer of the popular game Fortnite filed the lawsuit to prevent Google from negating the long overdue promise of competition in the Android app distribution market, according to the complaint. Allowing this coordinated illegal anti-competitive dealing to proceed hurts developers and consumers and undermines both the jury's verdict and regulatory and legislative progress around the world. But then there's also the ad control. Okay, Google did not immediately respond to a request for comment. Samsung said it actively fosters market competition, enhances consumer choice, and conducts its operations fairly. The features integrating our devices are designed in accordance with Samsung's core principles of security, privacy, and user control. We will remain fully committed to safeguarding users' personal data. Users have the choice to disable auto blocker at any time, Samsung said, adding that it plans to vigorously contest Epic's games' baseless claims. So they say. Epic launched its Epic Games stores on iPhones, the European Union, and on Android devices worldwide in August. It claims it now takes on an exceptionally onerous 21-step process to download a third-party app outside the Google Play Store or Samsung Galaxy Store. A support page on Epic's website shows a 4-step process to remove the auto blocker setting. Epic said those steps combined with Google's and Samsung's install flow are part of the 21 steps to download the Epic. Epic won its first antitrust lawsuit against Google in December after a jury found that the App Store had been protected by anti-competitive barriers that damaged smartphone consumers and software developers. The auto blocker feature was intentionally crafted in coordination with Google to preemptively undermine the jury's verdict in that case. Literally no store can compete with incumbents when disadvantaged this way. Epic Games CEO Tim Sweeney said on Twitter, to have true competition, all reputable stores and apps must be free to compete on a level playing field. Now, on to the ad blocker suit. Actually, there's several lawsuits that I'm going to go ahead and cover. So, I mean, there's literally several. Some that has already been settled out for billions, some for millions. So, Google's AI faces privacy law showdown. This was posted on September 4th, 2024 by Blake Landis of Troutman Amen LLP. This is a little bit of an older one. I believe this is one that they've settled. Justice Department sues Google for monopolizing digital advertising technologies. I've covered this particular lawsuit already. I don't think this is completely done. November of last year, they settled for $5 billion consumer privacy lawsuit. Okay, and yeah, I don't think people saw any money of that. I think that all went to, didn't go to the people that they violated, that's for sure. That they settled, and then they're now recently, complaining that it's in violation of, anyways, they said that the consumers said that they reached a preliminary settlement was over the settings that the Google's analytics, cookies, and apps let the Alphabet unit track their activity even when they set the Chrome browser to incognito and other browsers to private browsing mode, which I knew they were doing that because sometimes I would occasionally use incognito, and I would see that the things that I previously searched, incognito would reappear. So obviously they're tracking. I mean, that was a given. Particular complaint filed in September says that the Google's Cloud Contact Center AI, CCAI tool used by companies like Home Depot for customer service analyzes voices, transcribes conversations in real time, and suggests responses to service agents without callers' knowledge. It retains these recorded conversations in its databases to train AI models. So they stole your voice. So I hope and pray that they win on this. Google can access and use these recordings independently of its clients' customer support. How wrong is that, guys? Consumers are not even informed or given a chance to consent. Violates the law, Section 631 of CIPA, which bars wiretapping communications without all parties' consent. They are seeking to represent a class of all California residents who had their telephone conversations intercepted, recorded, eavesdropped on, or wiretapped by Google software without prior permission. Everybody check your Gmail spam because, yeah, you should be getting notification by mail, but for whatever reason, but this was a different one. There was also, so this is Ambriz, I don't know if I'm saying that right, versus Google, and there is the case number filed in Northern District of California, June 20th, 2024. But the Ambriz complaint alleged an agency relationship, while this one does not. Critically, the CIPA exception applied in Ambriz involving Verizon because it was limited to agents of phone companies and utilities. A label Home Depot is unlikely to claim. The question in this particular article is, will the plaintiff's claim stick? Google may argue, they're just speculating, that consumers implicitly consented to the recording via its client's privacy policies. But they're saying it wasn't clear, so therefore they did not consent. But courts have been hesitant to find implied consent to third-party snooping based on vague fine print. The complaint here says Google's role was never disclosed at all, which is a far cry from the crystal clear notice courts demand. I compare this to the particular YouTube content creators, the invalid traffic demonetization of channels, claiming that they have their friends or their contacts, which could be family, are watching their videos. It's like, so if you're a content creator, you're not allowed to have your friends, your family, or anybody that's in your contact, which could be fellow subscribers, that you've made friends with, nobody can watch your videos. If they, like, say, for example, if you have playlists and they just enjoy your stuff, they literally can cause your channel to be demonetized. I mean, but the fact that they're tracking who your friends and your contacts are for their purposes to determine whether or not your friends, and there's nothing anywhere of disclaimer that they can do this to you. And so that is an upcoming lawsuit. Rodriguez versus Ford Motor Company, plaintiff alleged Ford allowed a third-party software company to eavesdrop and record conversations between website visitors and Ford's customer service representatives, violating CIPA. But the court dismissed the claims for direct liability under SEPA with prejudice while dismissing the claims for aiding and abetting and for violations under SEPA Section 632.7 without prejudice, meaning they can refile, allowing a plaintiff the opportunity to amend and potentially refile the claim. So that's not completely done on that one. Then there was the recent, now this was already settled, Attorney General case, Bonta, said there was a $93 million settlement regarding Google's location privacy practices. And we have another false claiming that if Google allegedly falsely told users that if they turned off the location history setting, Google would not store their location device data. And this is the same thing as when you were turning your ad blockers off. That's the most recent complaint that's alleged, that just more settings that you turn off that's supposed to block them, and it doesn't. I don't think anything is blocked from Google. This is Epic staying the course dealing with Google, and they're saying that basically their auto blocker feature is, I guess they had a previous jury finding or conclusion that they're violating. That's the most recent accusation. In case you didn't know, back in August, Google lost an antitrust case over searches. A federal U.S. judge ruled Monday that Google has illegally held a monopoly in search and text advertising. And I agree they have. Now, I don't know that I haven't researched it yet. I will be doing that when I get the time, if it has gone to higher courts. But this was at this level. Now, will it go all the way to SCOTUS? We shall see. The Department of Justice and a bipartisan group of attorneys generals from 38 states, guys, and territories, led by Colorado and Nebraska, filed similar but separate antitrust suits against Google in 2020. And currently, the last count that I checked was there's 15 lawsuits against TikTok. They're adding, let's see, there's various suits against Instagram, TikTok, Facebook, Google, YouTube. Arkansas is taking into Google and YouTube specifically for privacy invasions, and just dealing mostly with minors and for more parental controls, which I completely agree with, and I pray that they win on that. So here is the Rodriguez case. Now, I will say this, be very leery. When you hear about these cases, you could potentially get basically scammers trying to present that, they're representing this case. So just be very careful, dealing with links. Contact the attorney. I will put the link to this particular case in the description so that you know who the attorneys are. You can look this case up yourself. This is the Rodriguez versus, basically the ads. So web and app activity. So people that don't want to have their ads personalized, or they just don't want their online or web and app activity, meaning when you use an app, you don't want your app behavior and activities monitored. When you go on the web, you don't want to be tracked, for purpose of ads or for any reason. So, yeah. The use of third-party apps to which Google provides services brings a putative class action against Google with 3 claims: invasion of privacy, intrusion upon seclusion, and violation of the Comprehensive Computer Data Access and Fraud Act. They seek certification of nationwide classes of all Google users who had all. Now, this is nationwide. Now, you may be somebody who uses Google's in other countries, but this is certified for this country. That doesn't mean that your country that you live in couldn't take up a similar lawsuit against Google, because Google is pretty much global, right? But just to clarify that, so there's no confusion there, it says certification of nationwide classes of all Google users who have their web and app activity and or supplemental web and app activity switched off from July 1st to 2016 until the date of this filing. So, concurrently, Google moves to exclude the opinion by plaintiff's damages expert, Michael J. Lisinski, pursuant to Federal Rules of Evidence 702. Basically, submit a report to calculate class-wide unjust enrichment and actual damages for plaintiffs' 2 proposed classes for the reasons below. Plaintiff's motion to certify class is granted, and Google's Daubert motion is denied. Now, anyways, but the notification, though, for people to have the ability to know about this so they can say, hey, I don't want to be a part of this class action, I will file my own suit or take my own legal action, you have to contact, you have to opt out. Otherwise, you will be treated as a member of this class action. That's how it works. And I don't agree with that, but that's just how it works. So that's why I think it's important for people to be aware of this. And the fact that I found some case about this case in my spam, because they're trusting Google to send the notifications to the people, I have a problem with that. I think Google has the address of every person. I don't know, maybe they don't, but I think that there are requirements for lawyers to make class actions known in the public. But at any rate, that's why I'm just saying, in case you didn't know, now you know, right? And so currently, I recently found out about, as a YouTube content creator, they are monitoring, or basically they're accessing my contacts, and based on a statement by YouTube in their what they call invalid traffic. So there are people that basically, they're kind of abusing the whole getting, watch hours or ad revenue, because they'll tell people to watch their videos and click on the ads, or two, they will watch playlists, but to me that's invasive, because one, they're trying to put themselves out as social media. So, why wouldn't you have subscribers who have subscribed to each other, and they encourage us to want other people to watch our videos, literally other subscribers. So if we, pray tell, happen to have personal contacts with them because maybe we've made friends with them, or we have, almost just for an example, a lot of people on YouTube do giveaways. And so they may have emails with each other when they're sending prizes out. That's just one example of why YouTubers would have personal contact information with each other, or they've sent tips to other YouTubers via, a lot of people do super chats, and a lot of people use PayPal. Now I know even channels that are monetized, because if you do super chat, you will basically get much less than if you had your tip through PayPal. So a lot of people do that, and a lot of people use their personal email for their PayPal. You just use it, you know what I'm saying? So there's a lot of different ways and reasons that YouTubers have each other's, you know what I'm saying? So for watching other subscribers' videos, they're literally demonetizing people and not even knowing why. And they're calling it invalid traffic. And I'm just like, darn well, if a guy or a girl or whoever is a YouTuber and their channel, especially if they're growing, we're talking big channels with hundreds of thousands of subscribers, were demonetized. And that was their sole income, right? And like one lady, it was for like 3 months. She was just like mortified, right? She had quit her job and this was her sole income. And there's so many examples of that. But you know darn well that their family's going to be proud of their loved one that's doing YouTube. And so, especially like, for example, people who live in other countries or far away from each other, and they're vlogging, and they're literally like their kids and stuff like that. And so, of course, they're going to watch every video they have. Those are their family members. And so they're like demonetizing them. But they're accessing their contacts, because Google has everything. They know your emails. They know anything. Every manufactured phone has Google default. And you can't even have a contact list. And all these lawsuits I've shared in this video showing that they have repeatedly, doesn't matter what your settings are, they have bypassed that. Right? So, yeah. So they're accessing people who don't even want to be accessed, right? For having their, like, it might be even a line phone number in somebody else's phone, and maybe maybe the old person doesn't even have a cell phone, but you have their address, you have their email or whatever, you have their landline phone, you know what I'm saying? And it's just not right that people who aren't even YouTubers, like, they just have access to all your contacts. And this is how, I don't know exactly how they determine, like, how it is that they go about, but they have all your contacts in their data so that they can set up their algorithm to detect, oh, this person's connected to this person watched this person's video, so we're going to call that invalid traffic and we're going to demonetize their channel, but we're going to make money off their videos. I'm seeing so many channels that have suffered from this. This is a class action lawsuit that's going to happen, right? And just this week, I had my videos taken from me. I don't know, but some of them are back. I did a video showing what videos were missing. And now some of those videos are back as of today. I contacted the CEO of YouTube, and I'm still contacting an attorney. I have been monitoring what they have been doing, and they have been taking my public watch time hours. And I've just been monitoring it just to see what they're doing, you know, and I hope for YouTube to get better. Really, I really hope and pray that these lawsuits bring change, especially for minors, okay? But anyways, that's it for this one, and please just be aware that you should check your Google spam folders of all your Google email accounts, and be careful, though, because spammers knowing about these suits may set up a phishing site, like, oh, hey, come over here and give us your information, you know, and then, you know, we'll make sure that you're a part of this class action. Well, I'm just saying, be careful. Contact the attorney over the lawsuit, okay? And their website should have that class action on their website. Whoever the lawsuits are, whoever the lawyers are handling the suit, should have that on their website. Just be careful. Anyways, but there's a lot of pending suits right now. Oh my gosh. Some of them are for damages. Some of them are by attorney generals that are, like, seeking, you know, change in their policies and etc. Okay? But anyways, I hope you have a blessed day.